Hello, everyone. It's Nicole Gaither, owner and founder of Creativa IP Law, a boutique virtual trademark law firm based here in New Orleans and soon to be in Washington, D.C. So, hello, welcome. Today is Tuesday, and that means it is another edition of Tipsy Tuesday. And for today's topic, I'm going to be talking about why brand names matter. And it's kind of going into detail of finding a really strong word mark for your trademark. So last week's topic, we talked about the question I usually get about whether someone should register a word mark over a logo, like how they can, get the most bang for their buck, and if they wanted to try to do, which one would be the best option for them. And of course, as I always say, a word mark is the strongest thing and it's the best level of protection for your trademark, of course, because it gives you a lot of broad protection. But there are some things that have to come with that. And of course, one of the things is, of course, making sure that if you have a word mark, that it is distinctive and unique. So we're going to kind of talk about what that means. And we're going to look at a nice little, of course, PowerPoint presentation that I put together and some examples of some trademarks that did not make the cut. And even one of them that's not even a trademark, which I thought was kind of funny that it even got to where it got in the trademark office. But without further ado, let's get started. So of course, let's talk about, first of all, if you're new and you're joining me, what is a trademark? And a trademark is a way, it's like a source identifier. It's a way for consumers to be able to find your product or service in the marketplace. And of course, it should be something that's distinctive so that your consumers are not confused with, your product and service. And then, it's very close in name with another product or service that's very similar. So it's a way for you to distinguish yourself to your consumers so they can find your products and services so that they don't get confused, so that you're not infringing on someone else's products and services, so that there's no question out there that, that person is not making a subsection of products and services using a name that you're using, anything like that. So that is what a trademark is. So think like Nike, Starbucks. Like Starbucks coffee is not the same as, Dunkin' Donuts coffee because they have different marks. Even though they're selling the same products, really, they are different because they have different trademarks. So without further ado, I think since we're kind of going into that, let's go to our screen share so we can look at what I'm talking about here. All right, so here's our PowerPoint. I'm going to pull it up. So of course, we are looking at, this is kind of a graph or a spectrum that I did to show you why, like looking at the types of names that you can use, and we're going to talk about each one. So starting with the strongest to weakest, and like a coined or fanciful mark would be something that is basically you came up with, like you put some letters together. It's not even a word. It's some, combination of possible words, but it's not a word that you can find in a dictionary. So that's a coined or fanciful mark. It could even include like numbers, anything like that. Arbitrary would be a word that actually appears in a dictionary, but it's not related to what your product or service is. So we're going to also look at those examples, but, kind of keep in the back of your head, Apple computers. So, Apple is a word in the English language. It's a fruit, but it doesn't really relate to computers. Suggestive would be, looking at something that kind of suggests but not exactly gives you an idea of what the product or service is. You have to use your imagination to get there. And it's, there could be a possibility where suggestive can be very close to descriptive, but, there are some ways to kind of look at that, and we're going to talk about that in a second. Descriptive is also, it's one of the weaker forms. It's when, you're using something that basically is almost an adjective to describe this service or product that you're selling. And that can also include like a geographic location in front of it. If you're using a surname, just something that kind of describes your products. So it's not exactly the strongest level of protection, because it's a possibility someone could have a name that's very close to yours and you might not have all the protection to kind of fight against them because you both have weak marks. And there's a possibility also where if you're using a mark that is descriptive, that you can eventually get trademark rights. You might get some trademark rights, you might be limited with the rights that you get. You might be placed on a register which is not as strong as a register. It's called the supplemental register. It's basically, you still get to use the circle R, but you don't really have that presumption of ownership. And, if somebody has a name that's very similar to yours, you're kind of weak too. But like the coined, fanciful marks, arbitrary and suggestive will appear on what's called the principal register. So they're considered, very strong marks. And we'll talk, there's actually, I'm going to kind of go into that topic at some point, but not today. About the principal and supplemental register. But I wanted to focus on really the names because this is really important. And then of course, generic, those do not get any level of trademark protection because they're basically telling you exactly what the product or service is. So one way to determine if you're using something that is generic, and let me turn this off, sorry. Let me do it this way so that it's actually a slideshow. Okay, so one way for you to determine if a name is generic is kind of looking at this test, asking these two questions. The first question is, who are you? And that would kind of tell you, if you're able to answer who are you, that would tell you if you're using a valid trademark. If you answer the question, what are you, then you're looking at really, that's kind of what you're selling, like that's your product. So like, who are you? Let's say you're a shoe company and you sell shoes. So what are you? You're a shoe company. So you wouldn't name your business shoe company. And then descriptive would basically like kind of give you a description of, it's like an adjective. It kind of gives you a description of what the product or service is. So kind of think of it describes a function, a use, a characteristic, size, or intended purpose of the product. Like I said, it's similar to an adjective. Think of surnames. They use a geographic location. So like Bank of America, Holiday Inn, American Girl, All Brand. These were all descriptive marks, but they were able to be registered because they acquired distinctiveness. They like became basically popular in the marketplace. So they got that level of distinctiveness so that they could be registered as trademarks. And they also appear on the principal register now. So that means like you can't go name your bank of Americana because it's too close to Bank of America. American Girl, you can't say, I'm sure there probably is an American Boy coming up very soon, but if you decide to name your doll company American Boy, you're probably not going to get away with that. All right, and I'm just making sure I'm not missing anything in my notes, so that's why I'm kind of pausing. So on the same level, the spectrum, we're actually moving from the weakest to strongest. I'm working backwards. So then we have suggestive names, and I'm going to move this out of the way so you can see. So suggestive names are similar to descriptive marks because it does relate to the product's characteristic or intended use, but your consumers or your customers are going to have to use their imagination to get the relationship between the mark and your products. So like extend your beauty. I mean, if I saw that, I would not even know what they're talking about. Okay, I knew it's probably a beauty product, but what type of beauty product? And it's for synthetic eyelash extensions. Legs, okay, so I know it's something for legs, but exactly what? It's for pantyhose. Glass doctor, okay, well, we know it's probably something to do with glass. Window repair. Now, whiteout and wet ones actually had to go all the way to court. I think even wet ones went to the Supreme Court, but these were ones that were found to be suggestive, even though they were very close to being descriptive. But of course, like what the court said was, even though you might have an idea of what it is, you don't really know. You have to use your imagination to kind of lead you to what it does. So whiteout is for correction products, and wet ones are moist towelettes. And then here are examples of arbitrary and fanciful marks. So we know camel is a word in the English language. I mean, it's for an animal. However, camel cigarettes have a strong level of protection because, cigarettes are not camels and vice versa. And of course, the usual examples, Apple computers. Apple is a word in the English language. However, when applied to or when used in connection with computers, it has a strong level of protection and it's considered an arbitrary mark. Same for Shell gasoline. And then we have the fanciful marks. These are marks that were words that were made up. So like Kodak was a made up term. Exxon was made up. And then also Clorox bleach. Those were made up terms and they're considered fanciful marks. I'm sorry, my phone is ringing. Okay, so we're going to get out of there. And I'm going to actually show you all an example of something that was put on the registry that ended up failing because it didn't meet the requirements. So let me go back to the screen share and I will pull up. All right, so let me get out of the way here. And then, okay. So I was looking for something like shoe. And well, let me go to the one that I wanted to use. All right, so someone actually did register shoes. They attempted to register shoes. They filed an application for shoes for, guess what? For shoes. So the word mark is shoes, and they attempted to register it for shoes. And this is way back in 1990. But it's basically a dead mark because you cannot register a trademark for what you're trying to sell. So they didn't get far with that. And then here is, I found new shoe smell, which was applied for in connection with fragrances for automobiles, and pre-scented strips and cards for sampling fragrances. And it also did not go very far. As you can see, it was abandoned because, and here is, it received an office action because it was deemed to be merely descriptive. The registration was refused because the applied for mark merely describes a feature of applicant's goods. You're merely describing that it's a new shoe smell, like new mean never worn before. Shoe is a durable covering for human foot. Smell refers to quality of something. So it was, descriptiveness was considered in relation to the relevant goods. In this case, the applicant offers fragrances. When they applied for a mark, new shoe smell is considered in relation to these goods. It is immediately and directly conveys to consumers that these fragrances consist of odors of unworn shoes. No thought or imagination would be necessary on the part of consumers to understand this descriptive meaning of new shoe smell when it is considered in relation to applicants' fragrances. So indeed, the applicant's website even notes that the fragrances being offered keep your shoes smelling new. And because applicants apply for a mark merely describes features of applicants' goods, registration must be refused under, this is the trademark section for basically merely descriptive. So it might even, in addition to being merely descriptive, the apply for a mark appears to be generic in connection with identified goods. So in essence, even though there was a lot of back and forth with this application, they ultimately ended up not getting the registration for it. So these are examples of, kind of from the spectrum of being weak, like the generic, like I said, with the shoes. Here's a merely descriptive one where it was refused registration because it was deemed to be descriptive and almost close to being generic for new shoe smells, for fragrances, for things to smell like new shoes, to ones that were descriptive, but eventually, because they had been in the marketplace for a while, customers were very familiar with it. So like Bank of America, American Girl, all brand cereal. And then moving on next to the next level, of course, which was the, those were the descriptive ones that ended up getting registration. Then we have suggestive, which were like the legs, the glass doctor, those which, kind of have a connotation of the product, but involve a little imagination to get to what the product is. And then, of course, the strongest level would be the arbitrary and fanciful, the ones that the words are possibly in the English language, but they don't relate to the product or service being offered. And then fanciful being the ones where you make up a word. So I hope this explains kind of why it is important, why brand names do matter, and why, of course, you do get the strongest level of protection depending on where you fall on the spectrum, how some words are not eligible for protection in the trademark registry. And they don't, qualify for trademark protection at all. And to the ones that, ultimately you can kind of, if you, select one that you've made up a word, there's a good chance that somebody else also did not make up that same word. Or if you picked out a word that was just kind of, random to relate to your product or service, it's a possibility that somebody else might not have picked that. So that's why those things are like high level, because there's a good chance that you're not going to have that issue of somebody else, you know, having something similar where there's going to be a chance for confusion. Where you start to run into the chance for confusion is where you have either something that's very close to something that's already out there and very famous. You know, like if you decide to go with Nike with a G, don't do that. I mean, you know, that's not even going to possible. Like if you use Gnike for your shoes. But if you're trying to use something that might be close to what's already out there, that's going to get you a refusal. Or if you have a name that, you know, is very close or descriptive or suggestive of what you're offering, then that also could get you into the whole, you know, issue of having a likelihood of confusion or refusal, because there's so many people who have things that are very similar in that area. So kind of stick to that top level of the spectrum, and I'm going to go back to it. Stay in this area of the spectrum up here. As you start to move further down here, you start to move into the area where you're either not going to get any type of protection, or you're going to start to run into the possibility of somebody else already having something very similar, and then you're having to explain why, you know, you both should either exist or why, you know, you should be able to register your mark. So I hope this has been helpful. Again, my name is Nicole Gaither. If you have any questions, please feel free to send me an email. It's Nicole, Nicole, at Creativa, and it's CreativaIP law.com. And you can also go to my website at creativaiplaw.com. You can post a question in the comments and I will answer it. So we probably, as you can tell, next week we'll probably talk about the difference between the principal and the supplemental register, just because we kind of touched on it, and just to kind of show you, like, generally trademarks that appear on the principal register are these, you know, 3 up here. When you start to get, you know, down here, like I said, no protection. But when you get to this area right here, like number 4, you kind of teeter on, you know, not having the strongest level of protection, and you might not appear on that, you know, really great registry. You still might have trademark registration protection. You still might be able to get the Circle R, but there are going to be some limitations. So we'll talk about that next week. And if anyone has any questions or anything that they want answered, feel free, let me know, send me an email, drop a comment, and I will talk to you all soon. So let me stop the screen share here, and happy Tuesday, and I'll see you all next week. Okay, bye.